Welcome to the special late night edition of our work session. Let's see, questions on the agenda? Okay, consent agenda?
Minutes for May 18th. I'm not sure if they sufficiently indicate that we brought up and then tabled the motion. I think we might want to look at that and make a clarification there.
What page is that, Aaron?
Facilities.
Oh wait, I've almost got it. It's
Page 16. It indicates my comments, but not the vote that we took.
so we could just add a sentence saying the vote on the policies was tabled until the what would it be, June 2nd meeting. Would that take care of your concern?
Indeed.
Okay, Joyce, did you get that?
Thank you.
Okay. Other questions on the consent agenda? Donald?
The special ed and preschool, what about that? Is that, I thought they had cut a lot of preschool stuff.
No increase in funding, so the state kept it the same number that they had the prior year. They did not cut it, they just did not funded what was in existence, right? Yes.
So we're not taking additional local money for this program beyond what we have in the past.
Well, that's a different, we get the state, and I think you know that, but we get the state preschool program, but we also have those special ed preschool where there are typical regular ed kids and also students with disabilities. I think we fund that exclusively. I mean, I know there's some federal money probably tied into it, but that's mostly out of local, isn't it, Jeff?
Yes, sir.
We've got about 5 or 6 or 7 of them throughout the county now. 13, wow, okay.
But we have been doing that.
Yes, sir.
That's not,
Nothing.
that wasn't any new programs in there. That's my question.
Okay.
And sort of related to that, somewhere in here, in the special ed information, it said something about the cost per special ed student was $4,700 or something like that. Does that ring a bell? Miss Bell, I shouldn't have used that phrase. So, somewhere in that paperwork, and I was just confused about that. I didn't know if that meant it was in addition to the regular per pupil spending, because obviously that's lower. Pardon?
That's a formulation to look at to see if we are supplanting anything from special ed or general ed.
So we want that number to be less than the per pupil? Okay. Are you the one that has to fill out all those forms? Bless you if you are. That.
On student fees, remind me again, we're not able to require that those fees be paid, but we can request them?
That's correct.
And what is the criteria by which, is there any criteria, is there any relationship between those fees and the free and reduced? Is that an automatic, or?
Angel, speak to that issue. I can answer it, but I'd rather she did.
That list of fees is not related to free and reduced at all. Those are fees that cannot be required of any student in public education, but can be requested.
And that's by statute, isn't it?
Yes.
You missed all that.
Yeah.
Yeah.
Have we seen a big drop in receipts since all that came about?
I would say there's been a fairly substantial drop.
Because there's some debate about whether or not the word is out on that, and apparently it is now. On that.
Well, it goes out in the student
It's in the
handbook every
manual,
year
right,
now.
right.
We scale back on field trips too.
Yeah,
Yeah,
which is
significantly.
unfortunate.
Yep.
Okay, thank you. I wanted to mention, Ms. Wise and the work she's done on the, and I can never remember the acronym, the, how do you say it? TSIP, what a massive document that is. Some of us were involved a few years ago during one of the viewings of it. If you haven't had a chance to scan through it, I'd urge you to do so. Some of the stuff in there is pretty striking. There's like 3 pages of additions that are in red in there. And I just had a chance briefly to talk to Mr. Odom about some of that, but there's a section called Evaluation of Prioritized Data, which essentially, and you all correct me if I'm wrong, but it seems to project the sort of gains we're going to have in each subgroup in order to meet No Child Left Behind in the coming years. And in my opinion, as a layperson serving on this board, it's not possible. I mean, it's just ridiculous. I'll take the most extreme case. In order to meet the goals for 2011, the reading, language, arts proficiency levels for grades 9 through 12 must increase in the limited English proficient subgroup by 54%. Now, there's all sorts of problems with that. By definition, they're limited proficient in English. Anyway, if you haven't taken a look at that, I would urge you to do it. I mean, it's some sobering stuff, and I know, Mr. Gill, that you're on top of it, and the staff is, but, I mean, you see, what's going to happen if this is not changed 3 years down the road, what's going to be the
Say
result?
most of the schools in the state will
Well,
be on
yeah.
target. You know, matter of fact, Mr. Odom and I were looking this morning, graduation rate, they've already backed off. Expect, what it's gonna take to make, graduation rate. Don, you wanna reference that a little?
They're changing percentages. We go to a meeting Thursday. We'll know more then. But they told us a few years ago they may go to a disaggregated graduation rate. I should know more again Thursday, so we may be swapping that all number down to, they've actually created another subgroup. They're now 10. So all 10 may have to make. I don't know where we go.
And as we were talking this morning, I don't know how anyone's gonna make ELL and special
Yeah.
ed. I just don't know. Anyway,
And changing that takes congressional action, right? I mean,
they'll
Right.
almost have to.
well, of course, we've been saying that for years now, and they still have not done it. Anyway, it's an eye-opener. I mean, we all are aware of this problem in its broad strokes, I think, but to see these actual figures is something. So I don't really have a question, more of a comment. Now, Don, what is it you gave me here?
That's the requirements for the next several years. That is the new one that was passed last fall.
Okay.
It'll be elementary at the top and high school at the bottom.
Okay, that'll give us sort of a reference to go by in terms of interpreting these figures. So beyond complaining, I don't really have a question. I just wanted to thank Amy for that good job that you did on that program. To put it on the consent agenda sort of underestimates the amount of work that I think probably went into that. On the other hand, I can't imagine that we're not happily going to approve it. But anyway, I just wanted to call the board's attention to those figures. Anything else on the consent agenda? Okay, number 7, we'll do Thursday, I assume.
Yes.
Oh, it is also on the, okay, I thought this was only on the consent agenda. Sorry, I stepped on your number 8 there.
A little finger there. Rutherford County School, Tennessee System-Wide Planning Process, TSIP addendum. TSIP is a planning process which replaces the Federal Consolidated Plan, the Technology Plan, the Special Education Plan, the Career and Technical Plan, and the Extended Contract Plan. TSIP is also the document that drives our Sachs-Cassie Advanced Ed certification. This addendum reflects reviews and revisions made during the 2010-2011 school year. This revised TSIP document updates the goals and action steps that will be implemented through the 2014-2015 school year. It includes our first of the top strategies. The The State of Tennessee's Department of Education is in the process of redesigning the TCEP template and recommends that district update the district data in component 3 and revise goals and action steps in component 5 as needed until the new template is released from the state. TCEP became the Rutherford County Board of Education's 5-year plan, which was originally approved in May of '06. All revisions are in red ink, and we recommend that you approve that.
Yeah, that's what, I'm sorry, somehow I thought that was on the consent agenda, cracking up here. But that's what I was talking about, so it's still an enormous amount of work there. Questions on that? Well, you have another shot on Thursday if you haven't approved all of those changes yet. Number 9.
Facility, Blackman High School softball building, Blackman High Principal Gil Vick has requested permission to construct a softball hitting building on the campus. The building will be a 50 by 80 post frame with metal truss roof with metal siding and roof constructed on an existing concrete slab at approximately $25,000. Funds for the project will come from the Blackman High softball boosters and no cost to the board. Rutherford County Engineering Construction Department's approved the site will inspect the building as constructed. And I might add that there are no title issues. There's a baseball hitting cage for the baseball team, and they've been sharing it with the girls, so that's not an issue here. And we'll recommend that you approve that.
Okay, questions? B.
Eagleville Sewer Plant Permit. The City of Eagleville is currently in the process of filing for grants to help finance the construction of the proposed Eagleville Sewer Plant. Eagleville Mayor, Ms. Sam Toombs, requested a letter from Rutherford County School Board permitting the transfer of the existing state wastewater permit serving Eagleville School to the City of Eagleville to use in the filing for grants. A copy of the proposed letter is included for review and approval, and we're going to recommend that you approve that letter. It might be good, Mr. Clardy, if you kind of get everybody in the loop with respect to what's being done out there, what the future holds for sewer usage.
We currently have a plant out there, and we're dumping into the creek that's close to the school there under a state permit. And it has a 18,000 gallon per day release design flow. Eagleville wanting to put a sewer plant in, but the state won't give them another permit to dump more wastewater, treated wastewater into the creek. So they need our permit to make the sewer plant or to get it permitted through the state. They need to use our permit for their release. So they're getting ready to file for the grants, and they need to include a letter in the grant that says that we will let them use our permit. And the letter that I have written here gives us the equivalent of 75,000 gallon per day release, which will take care of us now and future schools in the area. So the letter is to submit with their application so that the people they're applying to will understand that the board is on board with what they're wanting to do.
Okay, questions?
No, but I want to ask something. You remember a few years ago, the city of Murfreesboro asked us to, I don't know, I want to make sure I use the right terminology. We started irrigating Siegel and some other places with, what, wastewater?
Yes, sir.
How does, okay. Does that come directly from a pumping station or something, or after it's processed? I mean, how do we get access to that water?
The water is treated at the wastewater treatment plant. Once it's treated, it is put into a line and pumped back into the system through special lines that are separate, totally separate from the potable water. So, and only certain areas they have the line in, because it's kind of cost prohibitive to stick the line in. And but they have to try to get rid of that water so that they don't have to release it back into the stream, so that they can be within the guidelines of the state under their permit. I've even discussed with Smyrna, for instance, about getting it out to Stewart Creek High, and of course it's a great expense. It's over at the Nissan plant at this time, and sometimes they will extend it out, but they're watering the golf course. They've just put it around the golf course and those kind of areas, which is a good thing to do. And also the sewer plant at Eagleville, for instance, we would be able to take some of that repurified water off of that plant and use it at Eagleville School for irrigation. So.
Yeah, that's what I was looking for, repurified water.
Yeah.
Maybe wastewater.
Saved us a bunch of money though,
Oh,
at
yeah,
Siegel, didn't it?
absolutely, yeah.
Yeah.
I think, it was no harm to anyone, but we were concerned at the time, somebody might say, well, I don't want our field irrigated with, but it saved us a substantial amount of money.
Saves us a bunch of money. They, I can't remember what the cost is, but they basically give it to you just to get rid of it.
Okay, any other questions on the Eagleville? That takes us to the policies. Any discussion on those?
Yeah.
Aaron?
Get back to them here. I have two of them that are concerning me. Item D, policy 6.303. It would be my request of the board to take this policy that eliminates the requirement that the principal or designee be present during police interrogation and/or search, and return that back to the Policy Review Committee. I think that there is more review that would be appropriate, and I'd like to see it examined again.
Okay. Discussion about that? Aaron, do you want to go over your reasons? I mean, that, as I recall, that you were the only lone vote on that committee, so what made you?
Indeed, I was. As I understand it from the explanation we got in that policy committee, there were issues of privacy, issues of our staff being encumbered by subsequent subpoena and having to testify about what they witnessed during that. I did some additional research on the matter and went to the Tennessee School Board Association and inquired as to if they had any background or reason that this policy would need to be changed or updated. Joel Mosley told me that he was not aware of anything that made the policy as we currently have it as something that needed to be changed. He did indicate to me that perhaps it may be something given from the district attorney's office. So I got in touch with Bill Weitzel and spoke with him about it. And while he definitely agreed that we were not, we had no right, there was nothing that gave us the absolute privilege to be in the room, that he did not feel encumbered by our policy, that he was going to act in the best interest of law enforcement and was comfortable with that. I checked also with Sheriff Arnold and asked him about it. He was quite open with me that he did not want school personnel in the room when he's doing a police investigation. He explained to me that there was a circumstance where if we had 3 adults in a room and 1 minor, then the courts had seen that as an intimidating situation. And because of that, if he has 2 investigators there to corroborate one another and we insist on a third adult in the room, then it puts him in an uncomfortable position. So he certainly expects and would anticipate that he's going to ask for that school personnel to excuse themselves from the room. He also explained to me the conflict that he has had along the way with a principal bound by our policy who says, I've got to be in the room. And he says, if you insist on this, then you're impeding my investigation, and I'll have to take actions in that direction. So there certainly is a matter here that probably needs to be addressed. However, I see a big problem with us just simply taking the intent of a school person, a school representative, in the absence of a parent, taking any interest whatsoever. For me, it's a matter of that minor who is in a traumatic situation, has perhaps made an error in judgment, may be facing some type of investigation. We as a school system are turning and walking out of the room of our own accord. And I'm not comfortable with that. I am comfortable that law enforcement may excuse us from the situation, but I want them to do that. I want them to step forward and say, you need to step away now. I think that a more prudent policy revision would be to add a disclaimer that at the bottom of the existing policy gives a principle when local jurisdiction law enforcement prevails that the school personnel cannot be in the room, that we yield. And the school personnel are then excused from this mandate. But in the interest of the public and in the interest of our obligation in view of the parent, in place of the parent, I'm not going to willingly walk out of that room.
So you're saying your proposal is to say if they ask us or told us to leave, then we would leave?
Exactly.
Wouldn't they just tell us in every case then?
They can do that. But we are still in good standing with the parents who have entrusted us with the care and best interests of their children. We're also in good standing with the students who look to us for some type of redemption, a second chance, some type of recovery from this situation. We're invested with the student. We're in the process of them returning and being restored to a student in good standing.
Mr. Chairman,
Yes.
can we call on Mr. Reed to give his opinion, since
let's-
he's the board attorney?
Please do.
Are you up to snuff on this?
Well, as much as anyone, I guess. But, you know, the whole issue with respect to searches at schools and interrogating students at school is a complex issue. And it's hard to get one policy that paints with a broad brush all the situations that would be encompassed where police may be involved with respect to interrogating students on campuses. What the courts have looked at, and if you look at case law on it, the case law will tell you the courts kind of have distinguished three different situations where police investigations may take place at school. And they categorize them as in one category where there's a school-initiated search, where school officials basically handle a criminal matter and do the investigation on it, and the SRO officer is only very tangentially involved with it and is handled at the school level and really does not give rise to criminal charges, but there are things that may rise to a criminal level that are actually initially investigated by school employees and officials other than the SROs. The court in that case applies one standard. The court has a different situation where there is a law enforcement officer involved with respect to a situation that has in furtherance of an educational purpose. For instance, when you have SROs going through all the lockers to search lockers for some incident that's occurred in school. And there's a reasonableness standard applied by police officers in that case, which courts have upheld. And a third situation is where you have outside police officers come into school to conduct an investigation that really is not school-related. And in that case, the courts have said you have to give those type of students, they have to get full Miranda rights, and there has to be probable cause before the school people can talk, before the police officers can talk to those students involved with when outside police personnel come in to interview students or conduct searches on school campuses. So there's a distinction the courts have recognized, because this is not a new issue for the courts, because courts deal with these same type of issues on a daily basis in their juvenile court proceedings and in criminal court. So the court has said basically in situations where SROs are only tangentially involved or police are just tangentially involved and really the school personnel are the ones driving the investigation, and situations where there's educational purposes being fulfilled with respect to the police investigation or questioning that's going on, in those cases, there's a lower standard. The courts say in that case, there's only a reasonableness standard, and if the police have acted reasonably and the school has acted reasonably with respect to all the factors that led up to that investigation happening, and then there's some statutes that gives you a list of factors to look for to whether reasonableness has been met or not, then in that case, the search is okay. Any kind of criminal charge that comes out of that search is okay, and someone can be prosecuted in that case. Now, with respect to outside police coming into school premises to investigate something that has not been something arising because of school officials starting it, and it's really just outside police coming in to do an investigation on school grounds, they said, this court say, in that case, the police, you have to meet a higher standard to justify what you have just done. You have to have probable cause. You have to make sure your Miranda rights have been read. So that student's been, and Miranda rights are right. You have the right to remain silent. You have the right to representation by a lawyer, that's your Miranda rights. And that's a higher level criminal investigation at that point. But that does happen. So I think, if you're going to look at the policy, you may want to make some differentiation between what type of searches go on. You've got kind of a balancing act the courts have already trying to recognize, because the courts do recognize the roles of schools with respect to being, what some people say in loco parendis, the local parent of that child. They are in charge of the custody of that child while the student is there on your school campus. I think the courts have already recognized that the school is somewhat in that role and has developed kind of a case law which balances the interest of trying to protect the privacy and the integrity of the educational process, yet at the same time allowing these criminal investigations to be undertaken when they have to be undertaken. And the courts have found really it's not appropriate to have one broad standard for all those type situations, because you have different types of situations. And the court has said you really have to have, you can have maybe they've really adopted two different standards. One that's a pretty high, strict standard in the case of outside police coming into the school campus, and then a different lower standard for when really an investigation originates from the school itself and school related. So I don't know, with respect to the policy, you can debate what kind of policy you want to structure and how and what degree you want the school personnel to be involved with those investigations. I think certainly you would want to have an out for the police office, for the school personnel, so in the event they are directed to leave by the police investigating bodies or law enforcement bodies and are asked to leave, that they can permissibly leave under the policies the school board adopts without violating policy, because at that point you don't want the school principal or assistant principal arrested for impeding an investigation. So I do think it's appropriate to have some kind of exception so that in the event police officers do direct school personnel to leave, then in that case they would be able to honor that request and still be in compliance with school policy. So I think that would be appropriate for the school board to address in some fashion. With respect to whether we want to require school personnel to be present in all cases or not, don't know. I think that's a discretionary matter with the board, and I don't know from I think it probably would be appropriate to hear from local administrators kind of what their experiences have been and get maybe more direction from them as to what they think from a practical standpoint works best for them. Same token, you may want to talk to some more law enforcement people and say what works best on their end of things. Because we have, have two dual roles. You have the school system here trying to protect the educational process and the students make sure they get educated at school and it doesn't become just a a situation where they are just a criminal investigation venue for the police to come in and always just use the school's chance to undertake criminal investigations, because you do have students there for educational purposes. But obviously, a lot of times, the role the police officers involved with is something that the school probably would benefit from, in the sense that some of these ongoing criminal investigations may involve the school. So you have to, it's a balancing act, and where you end up at the end is something that's going to be a discretionary matter with the board. But I do not think it, by no means is the school board required to have someone present during interrogations at school. Same point, if you want a request to be present during interrogations at school, you can request that. But at some point, if the law enforcement officials tell you, well, we don't want you there, you have to leave, the school administrators at that point have to have the option of being able to leave and not being in violation of school board policy.
So they can kick out school personnel from an interrogation?
If it's an outside police investigation, yes.
You know, in response to one thing you said, Jeff, I had, and Angel could, I think, corroborate this. I don't think the principals have a keen desire to be in during the interrogations. One of the reasons being, I mean, if they're privy to information during that interrogation, they may end up offering testimony in court. Secondly, can we actually insist on being part of an interrogation? It's my understanding that if we said, hey, I know board policy is such that, you know, we want to sit in on this interrogation, couldn't they just take the child somewhere else and interrogate them?
They could, and that's when those standards come in, those probable cause standards, the higher standard kicks in that situation. Right. So you have to have, the police have to, for any criminal charges to be upheld that arise from that investigation, the child has to have been given the Miranda rights, and they're minors, so there's all kinds of factors that weigh into whether or not they were properly given their Miranda rights, because they have to have the capacity of understanding the Miranda rights. And that's a subjective type thing, and the courts recognize that's a subjective thing. Just because a police officer reads a 14-year-old their Miranda rights, courts did not automatically say, well, they were duly informed of the Miranda rights, because they may not mentally have had the capacity of understanding what that meant. And the courts they have a criteria, a checklist to go through to see whether or not they think in a particular case that's been met. So it becomes really complicated, and it's not a black and white thing, so you may have a police officer read Miranda rights, but whether that constitutes sufficient Miranda right reading, it's a case-by-case scenario.
If I can
let me also say that you have the higher standard of probable cause, which police, they can't, unless they have probable cause, they cannot undertake an investigation. So that is always kind of a point that police investigations are attacked by defense attorneys. They say, well, you did not, you found drugs in this locker here, but you didn't have probable cause to search to begin with. So therefore, the charges should be dropped, So that's another point. So the law enforcement officials have to be careful when they do come and conduct an outside investigation in school that they have met those higher threshold requirements of probable cause, Miranda rights are met, and so forth. So really, not having school board personnel that they're involved in the investigation gives the child, I guess to some extent, higher protection as far as the standards that have to be met by the law enforcement officials if any charges originate from the investigation going on campus.
And yet this policy would take us out of it, even in the most minor of school-initiated investigation, because the policy states 2 of the 3 areas that Jeff has outlined here. The search is not really covered at all. The policy addresses school-initiated investigation or interview and outside law enforcement interview. Only those 2 sections, and they're identical, and the proposed change is to eliminate school personnel from both of them. It's just a really complex issue, and the pervasive opinion that I have gotten from constituents is, in the absence of a parent, yeah, I want the school personnel present.
I just explained to clarify how this got to the policy committee. It got to the policy committee because administrators and law enforcement requested repeatedly that we take that provision out of the policy, because If we go with what you're suggesting, Mr. Holliday, there will never be a time that they will not ask us to leave. They never want an administrator in the room, and an administrator does not want to be in the room during that interview. And very, very seldom do these situations involve minor incidents. When a law enforcement agency from outside comes in, you're talking about fairly serious crimes, aggravated burglary, rape, statutory rape. Those are the ones that we have dealt with. And in an administrator, what I have gotten from administrators is, number one, you're caught between a police officer saying, you're impeding my investigation, which can be criminal on your own part, and if their interest is to protect the child, they're uncomfortable in that role as well. And what do you advise them? Do you answer? Do you not answer? They're uncomfortable in that role, and on the other hand, they're being told, you're impeding my investigation and you can't be in the room. So this was, the reason that it got brought to the policy committee to begin with was an attempt to clear that line that both the law enforcement officers and the administrators were requesting, please give us some relief and some clarification, because this is an ongoing problem for us. So, I mean, that's why it got to the policy committee.
Is there any benefit to the student from our current policy of having an administrator in there?
Practically, I don't think there is, because
Because
an
they're not
administrator
speaking, right?
is just going to be present in the room. I haven't run across a situation yet where an administrator has advised a student not to answer the questions, or, advise the student about, think about this one, or, any sort of advice for them. They typically are just present in the room. So as a practical matter, what benefit they serve to the student, other than in some cases specifically, it made it more uncomfortable because the situation involved some information that would have best been kept from that administrator probably.
Wayne?
Is there another way to do this, to have a policy where the law enforcement officials actually takes the student off campus to interview? Would that relieve us of our responsibility, that they can, if they want to interview, they can take to the juvenile justice center, or they can take to the adult center, rather than the school actually being involved?
Well, I think in most cases, what they're trying to do is to gather enough information to decide whether the child should be taken into custody or not. So they're probably not going to want to take the child into custody initially without doing some preliminary interview or investigation first, because what they may determine from the investigation or the interrogation is that that child does not need to be taken into custody. And I haven't discussed that specifically with law enforcement, but that's what I would presume they would say.
Chairman, I would suggest that school personnel have a unique perspective because they understand the educational capacity of the student. If they are a special needs student, if they are dyslexic, autistic, if they have any of these things, law enforcement is not familiar with that, but we are uniquely, in the same way that a parent would be uniquely understanding of those extenuating circumstances that go directly to whether or not they understand their Miranda rights or understand the situation that they're entering into at all. I think that our place is very much present there, and it's what the general public is expecting us to do. However, law enforcement absolutely has the right to excuse us from the room. I'm absolutely comfortable with relieving the administrators of the schools from this conflict that exists between the policy and the prevailing actions of law enforcement. We need to put that in place, but not at the expense of suggesting to the general public that we're turning our backs on children that make a mistake.
Angel, would that satisfy administrators and law enforcement?
I think that would be fine. It obviously would have to go back to the committee in order to make that change. I guess the problem that I have with it, and Jeff and I obviously haven't had a chance to talk about that, but if you follow that line of reasoning, and your reasoning is that we should be protecting the child's interest, but you're giving law enforcement the ability to relieve us of that responsibility, those two things don't mesh to me.
They're exactly the same as what any parent has if law enforcement shows up at the house. In the same way as the district attorney and the sheriff explained it to me, I have no right as a parent to remain in the room with my child, my own child, in this investigation. And so we simply maintain the same interest and the same presence that a biological parent would in their own home. We maintain that in our school where we're serving in view of the parent.
I think it's perfectly fine to do that. I'm just telling you, as a practical matter, we will never be in the room.
Right. I think clearly that's what would happen. I mean, I'm somewhat sympathetic to what Aaron's saying, and I think I said this at the policy committee. I did vote to approve this, just on the practicality of it. But there's something, I mean, I don't know. I think parents do look to the schools, rightly or wrongly, for that, some sort of support for their kids, even in this sort of situation. So I don't know.
We don't want to try and address every situation and every circumstance, but an additional factor here is that we create an environment with the SROs, which we incredibly appreciate the sheriff's office assisting us and participating with us in that regard. But we create a situation where the student is very trusting and has a rather warm relationship with that SRO, that if they see something around the school, they can tell that SRO, they can report that and everything. And in the occasion when that circumstance changes to an accused and an investigated individual, and law enforcement is pursuing them in that way, we potentially have blurred the lines a little bit about, is this my friend or is this law enforcement? Just exactly where is this? And I think that it's important that we maintain a position that we're looking out for the child's best interest all the way up to the point that law enforcement exercises their overriding rights.
Mr. Reed, since this board is your client, do you have a particular recommendation?
Well, there are issues with respect to the policy, and there's no, and I would send it back to the policy committee, let the policy study it more, let the committee look at all of the options that are available, and bring it back to the board for consideration. Because obviously there are questions about it in the minds of some board members' minds, at least, and if that's the case, I don't think there's any immediate need for this policy change, is there?
Well, I mean, the only immediate need is that this policy is in the student handbook, and so, if there's a version of it that changes subsequent to that being printed, then that's just additional information we'll have to send out. It would go in there as it is.
Right.
I would say, and I knew that Mr. Holliday called the sheriff because the day that you called him, he called me, followed up by Virgil Gammon, followed by Captain Henderson, each of whom is really insistent on the administrator not being in there. And I don't think there's a scenario where they're going to approve that administrator being in on that meeting. And secondly, if you would, just quickly, Angel, what is the consequence for an administrator being in that office? We've already said that, go ahead.
Well, I mean, the biggest consequence for them is that if there's a criminal prosecution and there has been information gathered during that investigation, then they will be called to testify. So it will pull them away from the school, during the time that they have to testify. And during criminal cases, that can be multiple occasions. So, not only are they uncomfortable doing the interview to begin with, but then they're being pulled away from the school subsequently during the criminal prosecution.
Why would they be, I mean, there's videotape in there, or at least there's a couple of officers to testify. Why would they need to call the administrator in that situation?
Well, in a lawsuit, you're going to call all potential
Just
witnesses.
everybody?
So the law enforcement people are going to generally try to back each other up with respect
Right.
to what happened. So I guess school personnel thought to be a little bit more independent.
Can I ask one more question? Why is it so important to law enforcement that an administrator not be in there? I mean, you're not law enforcement per se, but why do you think that is, one of y'all?
I think it's because they are trained in the ways of criminal investigation and criminal interviews, and in the same respect that in terms of investigating personnel issues, when they go over into the criminal side, we've had issues with that as well. When you're talking about a criminal investigation, that is first and foremost, and they take the lead on those things. They do not want any presence or any indication that will disrupt that criminal investigation. If there are comments made by the administrator that may sway the student's questions or answers one way or the other, that impedes the investigation. They want the best information they can get as quickly as they can get it. And the presence of additional people and comments back and forth tend to impede that. That's why my discussions with them have been they don't want additional people in the room.
Well, the more people you have, the more intimidating factor you have,
Right.
the number of officials in the presence of the child. That's a factor the court can look at, determine whether or not the child really was truly understood their Miranda rights and comprehended what rights they were told they had. So that's a factor that weighs
Under
in.
our scenario, the student would look at the school official, at least I think, according to what Aaron is saying, is someone more supportive. Right.
Well,
It
and
just depends on that student's
as
experience.
Sheriff
at
Arnold
school.
explained it to me, it was really that threshold of 3. You know, a typical investigation is going to have two law enforcement officers there to corroborate what one another heard, and then we would be the third adult in the room. And there's case law that suggests that 3 adults versus 1 minor, it's an intimidating situation, and all of a sudden you lose the interview. And so that was the specific thing that Sheriff Arnold related to me, and I think that that's really the compelling argument that pushes us out of the room.
And I don't know, in most cases, that the student's perception would be that the school person is a protective person, rather than someone, an additional person participating in the interrogation.
They're not likely to be honor roll students, is that what you're saying?
Not typically, although that has happened.
Yeah. So the motion would be on Thursday to refer this back to policy committee, Aaron. I believe that would
I think
be
it's
your-
appropriate because, if we change this, in board here, it really loses some of the influence that the policy committee is there for. So that's the direction that I'll go on Thursday.
Okay. Further questions?
I'm also concerned
Thank you,
about,
Jeff and Angel.
I'm also concerned about the policy under heading G, 4.301. And as I said in the policy review committee, I have a unique position here, as this is a policy that specifically addresses homeschool students, and I happen to be a homeschool parent. The ramifications of this is that Rutherford County will specifically exclude homeschool students from athletics, and that is in view of the decision that TSSAA made that would give them that opportunity. I think that this also is a complex issue. However, I voted for this policy revision, and I'll vote for it on Thursday. I just suggest to the board that we may see this come again as we continue to explore the relationship between homeschool students and the public school system.
Okay. Discussion on that one? Some of that may be driven by the General Assembly, if that does in fact happen, I imagine. Mr. Gill, you have anything to say on that?
No.
Okay. 11.
Career and Technical Education Committee report. The CTE committee's met a second time, I believe, and they've selected Brian Lewis to kind of update the board with respect to the status of those meetings. That'll be Thursday night.
All righty. We're going to do number 12 tonight or Thursday?
Thursday.
Okay. 13.
Also, we're looking into starting our own parent academy, which I'm excited about, and we'll give you an update on that Thursday night as well.
Okay. General discussion. Wayne?
Just that, from all indication, the spring fling went well. Utilization of several school sites. I'm not aware of any. The weather cooperated to the best of my knowledge, so we were a willing and active participant in that program. Really good for the county, helped with sales tax.
Yes, sir.
Did Mr. Gill want to talk about his meeting tonight?
Now, budget voted 7-0 to pass our budget at 266, 800,000, I believe. So it was a, cooperative meeting. I think that they're, really working with us and trusting in what we're doing, so I was appreciative of that. We've got a good bunch to work with.
Went very well. Other discussion? Hearing none, we are adjourned.